We're on to question 4 from the July 2022 bar exam. If you took this exam, you already know the subject matter. If you were on the bar, first thing you saw is 4 calls. First call, is the agreement between Aaliyah and Bowen valid? That doesn't exactly tell me the subject. Could be contracts or something else. Second call, is Daya bound by Aaliyah and Bowen's voting agreement with respect to the election of successor directors? Voting agreement, that is a topic in corporations law. So I assume this is corporations. Third call, on what theory or theories, if any, might ESGAR bring an action to enjoin Corp from moving solely into manufacturing bicycles? And what is the likely outcome? Well, that is most likely something that goes to a fundamental corporate change, or that we could at least argue represents a fundamental corporate change. That's what I'm guessing this is. It might also invoke, of course, the business judgment rule and the duty of due care. Still in corporations. Fourth call, on what theory or theories, if any, might ESGAR bring an action for damages against Palmer related to Corp moving solely into manufacturing bicycles? And what is the likely outcome? Okay, again, fundamental corporate change, violation of the duty of due care, maybe violation of the duty of loyalty. We'll have to see what the facts raise for us. Well, let's see what we've got in the facts. The Articles of Incorporation for Corp provide that it's a closely held corporation formed for the purpose of manufacturing televisions. Well, if I have time, if I don't have too many issues, I'm going to explain in my answer what a closely held corporation is. That it's one in which the shareholders generally hold offices as well. Corp has been highly profitable in this business for 20 years, which tells me, having already read the calls, that any decision to change the line of work that the corporation does, to change it from manufacturing televisions to manufacturing bicycles, is going to invoke the duty of due care and probably fundamental corporate change. Okay. The articles also provide that for the purpose of electing directors, each shareholder shall have 1 vote per share that they own, multiplied by the number of open director positions, that is, cumulative voting. Aaliyah and Bowen each owned sufficient shares to elect, through cumulative voting, one of the 3 directors of Corp. Aaliyah and Bowen entered into a signed written agreement stating that they will vote to elect themselves to the board of Corp and agree on the election of any successor board members, and if they cannot agree on a particular successor, will abstain from voting in that election. They also agreed that once they became directors, they would select Palmer as the new president of Corp. Okay, let's pull this apart a bit right now. Shareholders can form voting agreements. They can form voting pools. They can set up voting trusts. So the fact that they set up an agreement is not a big problem. Contract law is going to govern those agreements. And generally, those agreements will be enforced as long as they don't violate some other principle. So we have a voting agreement here. Each shareholder votes on directors. They elect the directors. So an agreement about how they're going to vote doesn't seem to be a problem. But what about agreeing on the election of any successor board member. That also looks okay. After all, one of the primary shareholder duties is to elect directors. They can also remove directors, but I haven't seen that here. But this business about once they became directors, they would select Palmer as the new president of Corp. But shareholders don't appoint the president. Directors do that. When they're signing this agreement, they're shareholders. They are usurping a core management function. They're, in essence, making an agreement that binds directors' discretion, and that's not going to be tolerated. That's going to be void. The agreement stipulated that it's binding on all subsequent owners of the shares. Aaliyah and Bowen stamped subject to agreement on the backs of all of their share certificates. Now, that's a wild provision, and corporations is not my strong suit. What am I going to do with that? Well, I'm going to calm myself down and realize that these agreements are governed by contract law. And what do I know about contracts? Well, I know that parties to a contract cannot limit other people's rights in their contract. In other words, they're trying to say, whoever owns these shares, this contract is going to be in force against them. But they're not parties to the contract. You can't, by contract, limit the rights of other people. So that provision is going to be void. These contracts are, the provisions are severable. So I think a court would strike that provision. What about the fact that they stamped subject to agreement on the backs of all of their share certificates? Well, that doesn't affect the rights of a third party. It may put a third party on notice that there's something going on with those shares, but it doesn't bind the third party to anything. So it would take more than that. It would take, in essence, a contract with the buyer, with the subsequent owner, who agrees to this. So I think the provision about agreeing to select Palmer as the new president is void. And the provision that says the agreement is binding on all subsequent owners of the shares is also void. And I don't think simply stamping subject to agreement on the backs of the shares is going to save that provision. But once you sever those provisions, the rest of it about voting for directors is valid. Aaliyah and Bowen were subsequently elected to Corp's board of directors, along with Chantal. At the next board meeting, Aaliyah and Bowen voted to select Palmer as the new president of Corp. Chantal abstained, and Palmer was named as president. Well, electing officers is within a board's powers, so I see nothing wrong with the fact that they elected him as president. As shareholders, they could not agree to do that in the future. It wasn't within their powers, but now they're directors, and it is within their powers. Next, Palmer immediately instituted several costly changes intended to shift Corp solely into the manufacturing of bicycles. Palmer reasoned that by the time the directors heard anything about the changes, Corp would be so profitable that no one would complain. That paragraph is pushing you, actually kind of slapping you in the face to think about the duty of due care and the business judgment rule and fundamental corporate change. Look at the words immediately instituted and costly changes. Would a reasonably prudent person have done that with respect to his or her own business? I think not, when the business was vastly profitable and had been for 20 years. There are no facts that show that he knew what he was doing or that he'd done some big study that said that that would be even more profitable. He just was going to do what he wanted to do, right? So I think that the business judgment rule is not going to save him, because that rule says that a court won't second guess a director or officer if the decision was in good faith and informed and has a rational basis. I don't see that it was informed or that it has a rational basis. So if the business judgment rule won't save him, won't save them, then the directors and officers who have breached will be jointly and severally personally liable for the harm proximately caused. And I would think that Aaliyah and Bowen, who are the ones who chose this guy, would be liable along with this new president. In any case, I'm going to need the facts in this paragraph for calls 3 and 4. And then what happens? Bowen discovered almost immediately what Palmer had done. Bowen then informed Daya of all these facts, sold his shares to her, and resigned from the board. Daya is the new owner. She's the subject of call 2. Is Daya bound by Aaliyah and Bowen's voting agreement with respect to the election of successor directors? So this is the call that gives me the most problem. Under general contract principles, as I said, I would say that a third party's rights can't be limited by a contract between two other people. But now, what do I do with the fact that Bowen informed Daya of all these facts and then sold his shares to her? Of all what facts? Of the fact that there was a voting agreement? Of the fact that if she bought the shares, she would be agreeing to limit her rights as far as future voting for directors? It doesn't really tell me that. And so if he did tell her all that, does that mean that that is an enforceable agreement against her? That's my problem with this call. So my bottom line thought is that without more, without some agreement, definite agreement between her and the seller, that limitation would be unenforceable against her. And now we find Esgar, who's call 4. Esgar, a shareholder of Corp since its inception, wishes to seek legal relief regarding Palmer's actions and Corp's change to solely manufacturing bicycles. And call 4 asked us on what theory or theories he might bring an action for damages against Palmer related to moving solely into manufacturing bicycles. So I'm going to think about shareholder derivative suits here, because Esgar owned stock at the time the claim arose, and he continues to hold stock now. So he qualifies, he has standing to raise a shareholder derivative suit because he wants to enforce the corporation's rights. It's being harmed. And that harm includes this officer's breach of the duty of due care. Okay, so I'm going to write up shareholder derivative suit for call 4. If he is successful, then the recovery goes to the corporation. He gets attorney fees and he gets costs from the corporation. Okay, go back to all the calls. Call 1, is the agreement between Aaliyah and Bowen valid? I think we talked about that quite a bit and answered that. Call 2, is Daya bound by the voting agreement with respect to the election of successor directors? We also pretty thoroughly discussed that one. Call 3, on what theory or theories, if any, might Esgar bring an action to enjoin Corp from moving solely into manufacturing bicycles, and what's the likely outcome? I think he would sue for breach of the duty of due care and ask for an injunction as his remedy. That breach of the duty of due care includes making an unusual change, a fundamental corporate change, without getting a resolution from the board, without notifying the shareholders, without approval by the majority of the shareholders entitled to vote. What's the likely outcome? I think that he will prevail in any action for breach of the duty of due care because the business judgment rule will not work. The decision that was made was neither rational nor was it well informed. And if we're talking about enjoining them from making that change, we're probably talking about needing a preliminary injunction, if not a TRO. A TRO is probably too time limited, but a preliminary injunction, yeah, to keep the status quo. But I don't think you need to discuss that, the issue of what kind of an injunction or what it involves, because the call specifically asks on what theory or theories, if any, might he bring an action to enjoin. So I think they're going after the underlying idea of violation of the duty of due care. On call 4, I'd go into much more detail about shareholder derivative suit. So of course, you may have seen other issues in this essay, and you may know more specific corporations law than I have raised here.